Ladies and gentlemen, esteemed participants and distinguished guests, it is with immense pleasure and pride that I welcome you all to the third Nalsar CCI Antitrust Moot Court competition. This year marks a significant milestone in our journey towards fostering a deeper understanding and engagement with the competition law in India. As we embark on this endeavor, it's important to acknowledge the evolving landscape of competition law in our country. Over the past decade, we have witnessed the emergence of a robust jurisprudence continually shaped and reshaped by the Competition Commission of India and various appellate courts and tribunals. The holistic practice of competition law in India is still in its nascent stages, and initiatives like ours play a pivotal role in stimulating research and critical thinking on emerging issues. The partnership between Nalsar and CCI underscores our shared commitment to promoting a serious conversation around competition law. The direct involvement of the CCI lends additional credibility to our efforts, further reinforcing the significance of this competition. Our vision for this year's competition is ambitious yet clear: to set the benchmark for antitrust law moots in India and to establish Nalsar CCI as a premier platform for engaging with competition law. To achieve this, we have spared no effort in ensuring that this moot promises to be the biggest and grandest, yet while maintaining the highest standards of quality and fairness. We have partnered with top law firms and research databases to provide our participants with best possible mooting experience. Our esteemed panel of judges comprises individuals with distinguished knowledge and expertise in the field of competition law, ensuring a rigorous evaluation process. But our commitment to excellence doesn't stop there. In addition to monetary prizes, we are delighted to offer internships, online study material subscriptions, and a plethora of goodies to the winners of various awards. These incentives are aimed not only at recognizing the hard work and talent of our participants, but also at nurturing their passion for competition law. The Winner Team Award, which includes a cash prize of Rs 1 lakh, internships with Trilegal for each member, and complimentary subscriptions to the SEC web edition, is just one example of the exciting opportunities that await our champions. As we gather here today, let us embrace the spirit of competition, camaraderie, and intellectual pursuit. Let us seize this opportunity to engage with complexities of competition law and emerge not just as winners, but as better equipped advocates and scholars. Throughout this journey, over the last 8 months, our partners have been our biggest support. Our title sponsor, CCI, Competition Commission of India, is a primary regulatory authority responsible for enforcing the Competition Act of 2002. Operating under the Ministry of Corporate Affairs, it plays a crucial role in maintaining fair competition and protecting consumer interests in the Indian market. The CCI's commitment to transparency, accountability, and efficiency contributes to sustainable economic growth and development in India. Trilegal stands as a beacon of excellence in the Indian legal landscape since its establishment in 2000. Its reputation for delivering outstanding integrated legal services across a wide spectrum of industries and practices is well known. Its commitment to excellence is reflected in its stellar track record in areas such as defense, dispute resolution, energy, infrastructure, labor, employment, and taxation. Trilegal's dedication to client service and its deep understanding of legal intricacies have earned it numerous awards and accolades over the years. As our esteemed title sponsor, Trilegal's support has been invaluable in making the Moot Court competition a reality. We are deeply grateful for their generosity and commitment to fostering legal talent, and we look forward to continuing our partnership and achieving greater heights together. Our knowledge partner, SEC and EBC, has set highest standards of quality and is preferred and most frequently cited law report in all across India. SEC Online is a groundbreaking platform offering a wealth of legal information and resources. With over 75 years of experience in law publishing in India, EBC has continuously innovated to meet the evolving needs of legal professionals. I am honored to introduce to you our esteemed chief guest, Mr. Augustine Peter. He was a former member, commissioner of the Competition Commission of India during the period of 2014 to 19, served as a first Director General when the enforcement of competition law started in 2009, served in the Ministry of Petroleum and Natural Gas, Government of India as Director General. He also worked many years as a Director of WTO-related issues in the Department of Commerce, Government of India, and looked after the competition policy, investment, transparency in government procurement, agreements on sanitary and phytosanitary measures, technical barriers to trade, besides being in charge of coordination of multilateral trade issues in the Trade Policy Division of the Department of Commerce. Your presence, sir, your presence here today fills us with immense gratitude and inspiration. Your accomplishments, leadership, and dedication to your respective fields serves as a guiding light for all of us. We are truly honored to have you with us as we embark on this exciting endeavor. May I now request Mr. Augustine Peter to please speak a few words. Thank you, sir.
Thank you very much for the kind words. I'm really happy to be here in Nalsar, I think for the first time, even though I have been here in Hyderabad a number of times. And all the more reason that I am in the middle of young competition law aspirants. I don't know, what do I say? So, I'm very thankful to Saurabh Bharati ji, who is present here, and welcome on my behalf all of you who have come from, I think, all parts of India to take part in this competition. When we are speaking about competition law and you are here to compete, so you know that competition, no, it depends. You don't go to any university. You come to Nalsar. Why? Because you know there will be good competition. If you can just walk over, you will not go there. No, because there is no challenge, and your best in you will not come. Competition is there because it brings out the best in enterprises. With the result, the country's national income, welfare, everything will go up. That is the presumption. And empirical analysis shows that it is a fact. Now, this type of moot court competitions that enables young minds like you to think more deep, because you may have a paper. I think many of the universities have got a paper on competition. There will be some minimal this thing and you just get through. There you don't get into the issues really, and maybe you have some internship somewhere. So there you get maybe slightly more. But moot, the problem, I have had a look. I am not normally supposed to comment on the problem because I may mislead you, I may guide you, as somebody will get a different direction. So we are not, I think normal practice is not to comment. But at the same time, I have seen that it's a cute little, because sometimes now the moot problems are so complex, layers and layers and layers. With the result, no, they may get diverted here and there. But this problem I find is a cute one with clear indication and related to, I think, catalyzation in the using the sort of digital or type of thing. So that is very relevant in the coming days. So it is, you are singularly benefited by participating here. And second, winning is very important, but participation and seeing others perform, how to improve, that is also very important. So I think I wish you, first of all, before speaking a few words, all the very best to each one of you for doing your best, showing your best possible, and respect for the whatever comes towards you. Now, I am really happy to be here because I have a shortcoming. I become envious. I got into competition law when I was much advanced in age compared to you because there was no competition law. My first encounter with something called competition law, that time it was MRTP, was in 1984 when I was posted to, there was something called the Monopoly Research Unit. Monopoly Research Unit in the Department of Company Affairs. Now it is Corporate Affairs Ministry. So there, basically I was in charge. My first posting was to see, because under the MRTP Act, there is a mandatory registration when you cross 20 crore of assets alone or along with other interconnected undertakings. 20 crore. Those days, 20 crore was not a small sum. So my main task was to go through all the balance sheets because we will get company affairs get the balance sheets. I was looking at the balance sheets. You compare. I found that one company, a sugar company from Chennai, was 21.5 crore and it is not registered already. So I went back to the previous year. Previous year, its turnover was, no, asset was only 3.1 crore or something. I was curious. So then I looked more into details. Then I found that actually sugar, that was a controlled, regulated industry that time. You can sell sugar only to the government, state government. And it so happened the state government did not lift the sugar. When the state government did not lift the sugar, what happens? It will lie in their godown, unlifted. They cannot sell anywhere else. So that is called stock in trade. Stock in trade is treated as an asset. So the asset as on 31st March became, because it was almost 17.5 crore worth of sugar was lying. I felt very bad because it's very unfair. I told my boss, the director in charge. Then he told, no, Mr. Peter, nothing can be done. You have to issue notice. So I felt very uncomfortable because I felt it is very unfair because somebody who is having 3.5 crore of assets, just because of the mistake or the laxity of the government, as on 31st March, its asset is 21 point something. But I could not succeed. It so happened in 1984, there was deregulation in the Indian economy and the asset limit was raised to 100 crore. Okay. So I think ultimately what I'm telling, so the MRTP Act had the precursor or whatever of Competition Act. It had certain restraining effects on the economy. I just wanted to tell that. Now, my second encounter came when I was in Commerce Ministry. I was in charge of WTO, as she very eloquently pointed out. So there in WTO, there were efforts to bring competition policy, investment policy, etc. to WTO mandate. There, Government of India was not interested in that, but at the same time, in Singapore, it was agreed that there will be discussions regarding trade and competition policy, the interface. So that day one onwards, I was looking after that, so used to participate in the meetings and all. As part of that, because there was an expectation that WTO may this competition policy issue will come, which will be of much higher standard compared to MRTP Act. Given that government was thinking that something should be done to modernize our law. So there was something called a Chakravarti Committee in the under Commerce Ministry. Dr. Chakravarti, who was a former member of MRTP Commission, I was the member secretary. So we recommended to the Government of India that this should be looked at. 1999 budget, the finance minister of that time then decided or declared that we will appoint a high-level committee and look at the issue. Raghavan Committee, I think all of you who are sitting here must be knowing the story from there. The Raghavan Committee, high-level committee came, and after a lot of consultation, the 2002 Act came. Okay. Thereafter, what was happening? 2002 onwards, there were a number of legal issues regarding the commission, the structure of the commission, because first the Competition Act 2002, as it was in the pattern of MRTP Act. MRTP Act had one, and then the appeal was to the Supreme Court. It was headed by a judicial person. So on the other hand, Competition Commission, the structure was supposed to be what? It was supposed to be an expert body, but the functions were of judicial nature. So somebody went to court in Madras. I think there are a lot of history which I don't want to. So with the result, 2007, it was modified, amended to have a two structure. CCI as a professional body, not to be headed by anybody, I think experts, can be legal, can be economic, can be administration. And then there will be an appellate body, competition appellate body came. Okay. So thereafter, appellate body was doing, it was growing, it was becoming, there used to be quick disposal. Then all of a sudden that was taken away. And the function was given to NCLAT. So there some issues came. I think most of you must be coming across that NCLAT may, because there is no specialized bench as it is. So with the result, no, it takes time. It is not competition law, as you know. It is not run-of-the-mill law. There are certain, that spirit of competition, understanding issues in a different perspective, that doesn't come by 3-4 hearings. So with the result, I think there are some issues. Now what is there? After this combat issue, now recently there were a number of amendments. I think you are all here because you know it. So I'm not going to repeat that. Now the jurisprudence of in respect to competition law, where do we stand? Do we all feel that there is sufficient jurisprudence available? Or is it we are deficient? Enforcement started in 2009. Now we are in 2024. Do we have sufficient jurisprudence on different issues? Yes, we have some. Which was the first one? First case where some directions were given regarding clarity on law. The Steel Authority of India case, where clarifications regarding 26(1), interim order, and DG's powers, lot of clarifications were thrown up by the Supreme Court, which was a lot of relief for the, otherwise every case CCI used to give a number of interim orders. Now interim orders have become also very a rarity, I think sparingly used. All the principles which are in the civil law, plus Supreme Court gave some directions regarding what is 26(1). It should be 26(1) plus there should be some added evidence or conviction by the commission. Then came the issue. See, I think one in between I have to say, as you have realized, competition law is basically, it is a multidisciplinary in nature. I myself, I am an economist. I belong to the Indian Economic Service. I came because of my constant interaction with law in WTO, in corporate affairs, and in CCI. So I got more and more attracted to law, and I did law in Delhi University. And then I was actually member economic in Competition Commission of India. So I am practicing all regulatory issues. So what I wanted to say is that unless you know bit of economics, and gradually more and more of economics, lawyers cannot be succeeding, will not be able to appreciate. That's why when I was advisor and then later DG in CCI, when we were trying to develop the organizational structure of CCI, that was in 2007-8. We also inducted I think, Bangalore National School in that direction. So finally, it was decided that there will be a 40:4:4:2 formula. What does it mean? 40% lawyers, 40% economists, and 20% financial analysts in CCI officials among offices. It was decided and it is still persisting like that. That's why lawyers, it is not just lawyers fiefdom, but there are number of lawyers who have caught up, who can stand up to some of the best economists. So what I wanted to say is that to succeed in this law, we should have fairly good and increasing understanding of economics. You can get analysis done by others, but you should be able to appreciate, is it not? When somebody briefs you, you should be able to appreciate and then present. You are the intermediary. That's the reason also why company secretaries and chartered accountants, they can also appear before CCI. Why economists cannot appear? Because we tried, I being economist, we tried our best. But the reason given was that economists, no, there is no, it is not a professional body. It's not a profession, because anybody can give an economics degree and there is no comparison. There is nobody is standardizing, nobody is monitoring. But chartered accountants, company secretaries and all, no, they have some centralized way of retraining and all. Economics means graduation, no, you can, you know. So the standards vary so widely. So our efforts did not, but at the same time, there is a possibility that in a case you can bring an expert, economist, and present before the commission. So that is very much there. So I was telling that now over a period of time, CCI has got a very good, I think some of them may be coming here also and you will be interacting. Very good officers, because they were recruited first in 2009, then in between 3-4 times. Very good, and they have been exposed to the best training programs. Most of them have been attached to European Commission authority, even FTC or to UK, different authorities. So some have been attached even for 3 months, 6 months. So there is a good capacity available in CCI as it is, both in terms of economics and law, and also good finance people. When it comes to mergers, amalgamations, acquisitions, if you look at, I think you will find that it's extremely important to understand the nuanced financial issues. And there are some good officers there in that respect also. Why I am telling that? Because sometimes you should try hard to get an internship there. And also there is a research associate, because as soon as you get out, because I am not talking because I have been associated with CCI for a long time. And this also, I think, is sponsored by CCI and Trilegal, again, another very important legal firm. So you should, I am only just highlighting that it will benefit you, because I have seen that research associates of CCI who have been doing well, they have been just getting, there is no ceiling into the compensation they get. So when they come into the, now coming back to the sort of jurisprudence that evolved. You know, economics, when I was mentioning the delineation of market, defining market and delineating market, that is very extremely important in respect of abuse of dominance and merger, amalgamation, acquisition. So there again, appreciation of economic concepts, that is extremely important. And penalty, for example, based on turnover. So that issue, Excel crop care case, I think most of you who are sitting here, I'm sure that you must have seen that. There, Supreme Court, because I for one, because members don't go to brief. That is an exception. I tried my best to convince the commission I want to go and brief. I also went with the legal team to brief our, I think, additional Solicitor General just to brief, so that the next day he was appearing in Supreme Court. But Supreme Court finally decided that even though it is specifically mentioned in the law, but the lawyers on the other side was able to convince the Supreme Court that it is the relevant turnover. So it took an amendment to the law. Now I think last week they have also notified that global turnover will be the case, but yes, because of that Supreme Court intervention, the EU practice of 30% of relevant turnover in certain relevant cases, but subject to a ceiling of 10% of global turnover. So it is the sort of iterative process. Supreme Court, I feel it was a wrong decision, but it was specific to that case. But then law had to be amended, and then we have now the mixed, that is basically relative to the European system. Again, another case, I think that is related to, I think your Moot problem also, that is cartelization. That was a case which I was sitting in judgment. That is Bharati Airtel and versus CCI, basically. So that was a case where the interface or the relation between sectoral regulator and CCI came. That was the issue. So we were very much convinced, even now I am convinced that cartel as such, the jurisdiction of CCI, and CCI issued a 26(1) order, but the Bharati Airtel and other incumbent firms, they did not appeal or approach Delhi High Court, because Delhi High Court has consistently been giving verdict in favor of CCI jurisdiction. So they went to Mumbai High Court. Mumbai High Court, and with a plethora of or a large number of best lawyers, and they got a order that CCI doesn't have the jurisdiction, because it is the jurisdiction, it is a sectoral regulator is there. It went to Supreme Court, and that is why Bharati Airtel versus CCI. Their Supreme Court came out with a decision which somehow I am not that happy, but Supreme Court stated that CCI jurisdiction exists, but since the sectoral regulator is there, sectoral regulator should first see and give its view, and then it should be seen by CCI. That is a case related to the sectoral regulator versus the CCI. So that is another decision which had come. So some jurisprudence was evolved, but yes, I think it has to come again and again. What happens, one issue which I find, I think most of you will be hearing here, there and there. After CCI, I think it takes long time for the case to be settled and final decision comes. Many cases which were supposed to be heavy penalty by CCI, lot of hue and cry, furor, and then it disappears. It goes to combat or now NCLAT, some decision comes and then everybody forgets. People don't even know whether it is finally decided. So when the final decision comes, it is now the latest case, I think one more I will refer. That is Google Android case, where CCI gave a verdict and penalized. When it went to NCLAT, NCLAT did not give a stay. So the parties, Google went to Supreme Court. I happened to be there also during that time. After hearing, Supreme Court also did not give stay, sent it back to NCLAT. NCLAT, that is why jurisprudence-wise I am telling you, Section 4, whether you like it or not, I may not like it, but the provision of law is that it is a per se. If you are dominant, if you commit any of these practices, then it is abuse of dominance. Okay. But it's very clearly laid down in the original act, but still, and when it went to combat, NCLAT recently, already then amended this thing, no, again it was reiterated in the amended section 4. But still, I don't know, from out of the blue, NCLAT stated that section 4 should be through the prism of rule of reason. So this is, I am only raising the issue. This is, I think, you people to think. As I have learned, understood, when the words of law is very clear, plain, then what right anybody has to go beyond that? Anyway, ultimately, what as on date, what NCLAT state, till it is overruled by Supreme Court, that stands. So what I was telling now, there are decisions, but I don't know, certain decisions or jurisprudence which has evolved, it is not that consistent with law. This is what I feel in some cases. Now, I think I don't want to prolong, because I think all of you are eager to reflecting on the case, and you have to enter the Goda and fight it out. So I don't want to go on and on, but at the same time, I want to say that competition law is a sunrise legal segment or area. It is worth specializing. I don't know, initial stages, maybe it is because it is a new route and it's a untrodden route. I think now most of the major law firms are doing practice in that area. So I think it is worth taking up. And it is more and more getting nuanced with the digital competition coming. And ex-ante regulation, I think that is the current ex-ante regulation of the digital sector. Again, there I have some difference of view, because the Parliamentary Standing Committee on Finance, they recommended that there should be an ex-ante regulation, because CCI does the regulation ex post. Once the issue has happened, violation has happened, then look at it and then except in the case of combination. But here, digital sector, they say that digital is a fast changing. It is changing so fast. By the time we sit in judgment 3-4 years, then the scenario has changed. So ex-ante regulation, you give them a certain, just like telecom regulatory authority does, or ex-ante regulators do it. After the Parliamentary Standing Committee, another committee was set up under the chairmanship of Corporate Affairs Secretary. That committee has again come out with a report last week, where ex-ante regulation they have again recommended, and it is subject to comments. It is open for comments by all of us. So I think you can have a look at it. So digital competition law, it is also very much into the picture. I don't prolong more. I am really happy. I think I am benefiting by just the presence of all of you here from all over the country, and the interest that you are showing in a subject which I have lived maybe over maybe a quarter of a century. It's a too long time for you people, but yes, thank you very much for inviting me, and I am very happy to be present here. Thank you very much.
Thank you so much, sir, for enlightening us through your speech. Now I request Faculty Coordinator of the Moot Court Committee, Professor Saurabh Bharti, to please speak a few words.
I'll be very brief. First of all, it's a privilege that we have Shri Augustine Peter with us. So your presence for this inauguration adds to the gravitas of the competition. And this is, as I understand, your first time to Nalsar, although you've been to Hyderabad many times. But I'm sure that this is just a start of longer collaboration. We would have more opportunities to have you with us for more programs, including academic engagement with you. Let me also welcome all the teams for this third edition of this competition. I'm very happy to sort of convey to all of you that this time we had close to 110 registrations, which is a record for us. We hold 3 moot court competitions at Nalsar, and This one has therefore become the most successful of the three which we host. Out of 110 registrations, of course, 24 teams are here with us on campus for the physical oral rounds. Whenever we go to any moot court competition as a student, when I was also a mooter, there are primarily we wish that we would go and win the trophy. And we also have another wish, which is that we carry back good memories and a sense of enrichment about our participation in an academic exercise. So with respect to the first wish, I don't think I can sort of assure you victory to all of you because only one team invariably would win. But the second, dimension of your wish, I can assure you that our team, the organizing committee and the moot court committee, have really put in a lot of effort to ensure that we give you best of, the opportunity to engage with such a complicated area of law, both in terms of the problem which is for you to delve upon, and secondly, the quality of judges which we have who would be listening to you while you are presenting your cases. At the end of the 2 days of rigorous competition, I'm very hopeful that all of you would feel immensely enriched by your participation. And of course, only one would get to have the trophy. That's always part of the competition. Also, the fact that this competition is organized in collaboration with CCI and it is supported and sponsored by Trilegal adds to the credibility of the competition in many ways. And I don't think I'll be, feeling I think I can say it with a sense of assurance that this is the most credible competition on moot court competition on competition law in the country. And that is why maybe there are 110 registrations for this. Before I conclude, I want to sort of appreciate the efforts which the organizing committee has put in. Of course, they've been working tirelessly all these days. The real test is still to come, which is the next 2 days. I'm hopeful that their hard work will bear good fruits, and we would have hiccups-free, intense competition where everybody feels happy at the end of the day. But in case you have any issues, any problems, don't feel hesitation. Reach out to us. You can talk to me. You can write to me, and I assure you that we would ensure that we address your concerns, as urgently as possible. So I wish my team all the best, and I wish all of you all the best. It starts tomorrow morning. I hope all of you would have a great time at Nalsar. Thank you.
Thank you, Professor Bhati, for your kind words. And thank you so much to Mr. Peter also. Mr. Peter flew all the way from Delhi to Hyderabad just to be with us and for sharing his insights from all the work that he has done in the competition commission and all of his professional life. Professor Siddharth Chauhan is also with us here today. Thank you so much, sir, for taking out your time and being with us. Professor Chauhan is a guiding light for all of us here at Nalsar. Sir, I know the topic might not be 100% relevant for you, but if you can share a small story or something, a few words of motivation, that would be. Well, thank you so much for being here. And I think we can proceed with the lightning lamp if you want to speak a few words.
As we gather here to inaugurate the third edition of the Nalsar CCI Antitrust Moot Court competition, we are reminded of the significance of this tradition. Lighting the lamp symbolizes the dispelling of darkness and ushering in of light, wisdom, and prosperity. It is a momentous occasion that marks the beginning of our journey towards knowledge, enlightenment, and collaboration. Now I request Professor Saurabh Bharti, Mr. Augustine Peter, Vikrant Saraf, Professor Siddharth Chauhan to please light the lamp. Thank you so much, respected sirs. Now, I would like to request Mr. Augustine Peter to please open the moot.
Uh, Thank you so much, Mr. Peter, sir. I don't think I have to speak anything else. Sanidhi and Professor Saurabh has covered everything. We are really happy to welcome all of you at Nalsar. We really hope the next couple of days are hassle-free for all of you. We're going to see some tough competitions in the next 2 days. We are having esteemed dignitaries coming from the Competition Commission, from the Trilegal and various other senior advocates and judges from Telangana High Court. And that's all from our side. I think there cannot be enough thanks to Professor Bharti for helping us organizing this moot, sir. Without your help, we wouldn't have been here. And to Mr. Peter for flying all the way from Delhi just to be with us, sharing his insights. Thank you so much, Mr. Peter, sir. And I hope you keep visiting Nalsa in the future as well to share more of your insights. And we would look forward to that. Thank you so much, everybody. And I wish you all the very best for the competition. The teams can stay back just for 5 minutes.
A piece of information to all the teams. So at 7 o'clock, you guys are going to have researchers test. Until then, you guys can roam around the campus. There are a lot of food trucks, and you can just view Lansar. And if you have any queries, you can always approach us. There are volunteers, there are OC members, and there are your POCs too. Thank you. Again, information to the participants, please stay back. I announce again, please stay back. Sorry for the inconvenience, but we will be starting with the briefing due to paucity of time. Sorry for the inconvenience once again. You are allowed to leave.